I would like to flag two critical issues for the committee's consideration. Both issues will be central to ensuring effective patient access. These are, first, how can we ensure that the legislative and regulatory framework achieves an appropriate balance between physicians' ability to follow their conscience and patients' ability to access physician-assisted dying? And secondly, how can we ensure that we emerge with a consistent pan-Canadian framework? This last issue, that of conscientious objection, is one that we would like to discuss in more detail, as it is of particular concern. I'll now turn the microphone to my colleague, Dr. Jeff Blackmer, to discuss this issue.
Thank you, Dr. Forbes. Thank you, committee members. Ensuring effective patient access across Canada in part will depend on how this issue will be addressed. I'd like to point out that a key focus of the CMA's work has been to ensure that both physicians and the patients for which we care are represented in the overarching regulatory and legislative response to the Carter decision. As it remains in society, assisted dying is a difficult and controversial issue for the medical profession. It must be recognized that this represents no less than a sea change for physicians in Canada. As the national organization representing physicians, I cannot underscore enough the significance and the importance of this change. As we have mentioned, the CMA has extensively consulted physicians before and since the Carter decision. Our surveys and consultations indicate that approximately 30% of physicians indicate they would provide assistance in dying. It's important to note that for the majority of physicians who will choose not to provide assistance in dying directly, providing a patient with a referral will not be an issue for them. They will not consider it to be a violation of their conscience or of their moral code. For other physicians, however, making a referral for assisted dying would be categorically morally unacceptable. For these physicians, it implies forced participation procedurally that may be connected to or make them complicit in what they deem to be a morally abhorrent act. In other words, being asked to make a referral for assisted dying respects the conscience of some physicians, but not of others. Part of the obligation of government and stakeholders is to ensure effective patient access by putting in place sufficient resources and systems. The CMA's framework accounts for differences of conscience by recommending the creation of resources in order to facilitate that access.
Dr. Blackmer, I would like to come back and to Dr. Forbes' statement that you made in your opening remarks, which is troubling to me, which is that 30% of the physicians that you have canvassed have answered that they would provide physician-assisted dying. It means that 70% won't. While the Supreme Court has stated very clearly that a person has the right, according to Section 7 of the Charter, to request assistance from a physician, you have to reconcile the freedom of thought or the freedom of conscience of a doctor or physician under Section 2B with Section 7. Which one prevails in such a case? Could you be very clear on what is your position in relation to a physician that would feel hurt in his or her conscience if he or she would be compelled to provide assistance in dying, and what is the responsibility of that physician in relation to advise or to refer the patient to a proper service or proper information so that that person could seek the support it needs to get in the circumstances.
Thank you. And that is essentially one of the main issues that we've been dealing with. And I think it would be important to actually focus on what we feel is the responsibilities of the physicians. And we feel that those physicians who are not willing to provide the service and who may feel that a referral is also against their moral beliefs, they do have responsibility, and that would be to advise the patient on all of their options, have the conversation that we've talked about on all end-of-life options, including physician-assisted dying, and to make sure the patient has the information they need to access that service. And when you mentioned only 30% of physicians willing to provide the service, I think you have to look at, we're expecting less than 3% may actually choose this option. We have about 82,000 member physicians for the Canadian Medical Association, so you're actually talking about a large number of physicians. So then you're really talking about distribution and access, to care in different regions, and so I think it helps to put it in perspective. And I know Dr. Blackmer wants to comment as well.
Thank you. So I think it's absolutely critical to recognize that 30% represents 24,000 Canadian physicians. I can sit here today in front of this committee and guarantee that from simply a numbers perspective, access will not be an issue. It's really about connecting, as Dr. Brannigan has already indicated. It's about connecting the people that qualify for assisted dying with the providers that are willing to undertake assisted dying with that patient. The whole issue of connecting access with the right to conscientious objection is a false dichotomy. The two are not interrelated. In fact, we have a very small percent of members who said we feel very conflicted about the obligation to refer. However, the entire rest of the profession says, even though we may not share that view, we will fight for your right to be able to not have mandatory referral. So if you have a tiny percentage or a very small percentage of the profession, a very small percentage of patients actually requesting assisted dying, that is not going to any way impact access. And the final point I would make on that, and I think it's a critically important one, no other jurisdiction in the world has a mandatory effective referral. None of the jurisdictions that currently allow either assisted dying or euthanasia have mandatory effective referral. Access is not a problem anywhere. I can guarantee on behalf of the medical profession that access will not be a problem because of respecting conscience rights. We still have work to do in rural and remote areas. That's another issue.
Will that be part of the instructions or interpretation that you will provide to all the medical profession in terms of the Provincial College of Doctors, who have the responsibility of the deontology and ethics in relation to what is their role in relation to physician-assisted dying?
They're very clear of our views on this issue, yes.
Thank you.
Thank you very much for that question. And we did actually explore that a little bit with our membership, not in a very granular way, but when we asked them what your level of support would be overall, we came up with a number of around 30%. Once we started to add in some additional factors, so for example, if the pain and suffering is purely psychological versus physical as well, the support drops. Once we add in a non-terminal versus a terminal illness, the support drops again. And so you can see the level of discomfort of physicians will increase as we add in more of these variables. We didn't use things like age or the possibility of using advance directives as variables specifically, but in the conversations that we've had with our colleagues, there's a lot of discomfort around that as well. So our starting point for a lot of the discussions was the Carter decision as we interpreted it, which is not what some people are calling Carter plus, but more the floor than the ceiling, I think. And the more variables you add in, the more difficult healthcare providers find those scenarios, and the lower the support and the lower the percent of providers willing to step forward and provide assisted dying becomes. So it's not something that we consulted the membership on. What I can tell you is that in real life practice, putting advance directives into action is incredibly complex and difficult because it's very hard to capture all the nuances and the specificities of a very complicated medical condition and intervention. So even in the best of situations, physicians have a lot of difficulty actualizing an advance directive. And what our members have told us is that they see a lot of potential difficulties if we were, especially right out of the gate, in this type of a novel intervention, very complex set of circumstances, at the same time layer on the concept of providing advance directives. that would, again, be one further level of complexity that it would make it more difficult for a lot of physicians to participate and actualize the assisted dying process. So it's not our official policy, but I would caution that it opens up another whole set of circumstances.
Under your recommendations, under 5.2 regarding conscientious objection by a physician, it says physicians are not obligated to fulfill requests for assisted dying. This means that physicians who choose not to provide or participate in assisted dying are not required to provide it or participate in it or to refer the patient to a physician or a medical administrator who will provide assisted dying to the patient. There should be no discrimination against a physician who chooses not to provide or participate in assisted dying. That's the official decision. Would this apply to physicians and facilities and organizations, or just physicians?
It applies only to physicians.
So your recommendation is based on consultation with physicians?
We're very clear on the fact that if left at the provincial level, we will have a patchwork. We already do have a patchwork. As I said, it's no longer a theoretical concern. It exists in reality now, and our members are telling us about their concerns. I have phone calls every day saying, I live in this province. I think I'm going to move to this province because I like their rules better, and they coincide better with my own moral views.